The Canadian Charter of Rights and Freedoms, one of the most controversial and sensitive subjects not only in Canadian law but all throughout Canadian history. Some claim that the document has done only good for the whole of Canadian society by giving people the rights that they are entitled to. Others claim that the document is one of the worst things to ever happen in Canadian history and that it is tearing apart our legal system by only helping common criminals escape the punishment that they deserve. The source of all this controversy may be much deeper, however, than a mere document. For the Charter of Rights controversy goes hand in hand with another issue, or rather person, that has split Canadians for nearly 40 years. That person is Pierre Elliott Trudeau. Trudeau, who served a grand total of 15 years as Prime Minister of Canada, was the initial creator and instigator of the libertarian rights movement in Canada, which would ultimately lead to the creation of the Charter of Rights and Freedoms. Known for his laid-back and arrogant attitude, Trudeau has become infamous all across the country for his over-the-top persona. As seen in this video from 1970, at the height of the FLQ crisis, Trudeau shows his confident, yet arrogant, egotistic attitude towards the controversy surrounding the decisions he made in that time of national insecurity.
There's a lot of bleeding hearts around who just don't like to see people with helmets and guns. All I can say is go on and bleed, but it's more important to keep law and order in this society than to be worried about weak-kneed people who don't like the looks of a soldier.
At any cost? At any cost? How far would you go with that? How far would you extend that?
Well, just watch me.
This quote, "just watch me," has gone on to become the most famous words Trudeau said whilst in office. But all this controversy amounts to nothing without clear, concise facts. Especially in these instances, everyone has an opinion and side. But like most debates in the world, there is usually truth found in both sides. When we strip away all the biases and prejudices, what are we left with? Is there some worth found in the Charter of Rights and Freedoms, the masterpiece of Pierre Elliott Trudeau? As already stated, the Charter of Rights is a libertarian document. In essence, this means that it is centered around a belief that all individuals in society are entitled to specific rights and freedoms that no one can take away from them. The contrasting view to this would be collectivism. The Canadian Bill of Rights was the collectivist version of the Charter, or rather, the Charter was the libertarian version of the Bill, as the Bill of Rights was created first in 1960. Its creator was Prime Minister John Diefenbaker, who in many ways was Trudeau's opposite. Diefenbaker was a conservative, while Trudeau was a liberal. Diefenbaker was a collectivist, Trudeau was a libertarian. But what exactly is the difference between libertarian and collectivist? If each respective party just wants to defend Canadians' rights, does it really matter how it gets done? To answer this question, one needs to be aware of the implications the two different views would have on individual cases. In the example of a murder, a collectivist document would attempt to punish the criminal fairly and justly, in regards to the crime they committed against the collective society and the further threat that they pose on society. A libertarian document, on the other hand, would be more concerned with the murderer being punished inside of his rights. It is here that some of the extreme controversy comes in. Many people feel that under the Charter, criminals are underpunished, as their lawyers claim that jail sentences, circumstances surrounding arrest, and court proceedings violate the individual rights and freedoms that the criminals are entitled to. Many judges tend to stay away from even appearing to violate the Charter, and as such give in to the arguments made by the criminals and their lawyers. Another controversy under the Charter is the power of the Supreme Court judges, of which there are 9 non-elected positions in total. These judges can eliminate any law created by Parliament if they believe that the law violates and trespasses on someone's rights as laid out in the Charter. An example of this type of action carried out by the Supreme Court would be the famous case of Regina v. Morgentaler in 1988. Dr. Henry Morgentaler, who along with 2 other practitioners, attempted to set up an abortion clinic in Toronto, Ontario, that would allow any woman to come in for an abortion. At the time, abortions could only be committed after special approval had been granted to the woman by a certified hospital. Morgentaler brought the case to court and claimed that the laws against abortion violated a woman's rights over her own body, as laid out in the Charter. The court ruled in favor of Morgentaler, and federal laws regarding abortions were struck down. The ruling is one of the most controversial in Canadian history, and to this day, many still disagree regarding the decision. But at the heart of the case, the issue has absolutely nothing to do with abortion. Many feel that these judges, who are not elected by the general public, should not be able to strike down these laws made by Parliament without any process or approval. After all, If Parliament is truly the supreme power in Canada, shouldn't it not be able to be overruled by a single judge? Parliamenters are elected representatives in this democratic society. They act on behalf of the people, and thus their word is law. Why should one of 9 people be able to overturn these decisions at any given time? Does this not give Supreme Court judges some attributes of a dictator? Since the inception of the Charter, other cases have come forward regarding privacy, beliefs, and criminal acts. This has caused a backlash against the document, many claiming that the Charter is doing more harm than good and that it should be amended, as it is only allowing criminals to escape the punishment that they deserve. However, to change or remove the document is far easier said than done. When Trudeau created the Charter, he made it a part of the new Constitution that he created, the Constitution Act 1982, which replaced the former British North American Act 1867. To now change the Charter, one has to change the entire Constitution. This was attempted by former Prime Minister Brian Mulroney on 2 separate occasions, in the Meech Lake and Charlottetown Accords of 1987 and 1992, respectively. Each accord did not grant the proper approval necessary to amend part of the Constitution, which required a unanimous affirmation amongst all the provinces and their legislatures. To this day, the Charter still remains in effect, much to the chagrin of some and the triumph of others. No one can deny the positive effects that have come around from the human rights guaranteed in the Charter. All of us appreciate our rights to print our opinion in the press, be mobile, speak freely, practice in any religion, believe what we want, meet with whoever we want, and belong to almost any group that we want. These rights are helping Canadians keep a free, democratic society where we can live in peace. But the Charter, like many things in this world, may have carried it a little too far. How far can rights be extended to all people, even those who have murdered, robbed from, and traumatized others? Is it fair that they are still entitled to these rights? How can we have the best of both worlds? Freedom for the innocent and fair punishment for the guilty. Despite whether or not the Charter has actually helped to make Canada a better place, it appears that the country is going to have to live with it for a long time to come. Many of us, then, are just going to have to get used to it.